First off, I'd like to say thank you to John, thank you to Lindsay, thank you to the NKU Law Review and everybody who actually planned this event. As John mentioned at the beginning, I am the guest from Dayton, meaning that I'm just up the road, and I'm extraordinarily happy to be just up the road in the sense that I'm extraordinarily excited by John's work. You know, in addition to the bright flashing lights of this building and everything that goes along with informatics, there's a lot of substance that John brings to the table. It's an exciting topic that allows for a tremendous amount of interdisciplinary study, meaning it's a real honor to hear all of the lectures that we heard today on the real variety of topics. And then finally, as an academic, one of the things that I have to engage in is narcissism. I study securities regulation, and when I heard John present, and he came to Dayton and gave a speech to the faculty talking about disruptive technology, talking about the distribution of information, I thought, hey, I do that. That's exciting. That's securities regulation. I realize that there's a wide variety of experience in the crowd in terms of the fact that there are some people who probably know a lot about securities regulation and some people who don't know anything at all. Meaning that, for example, when I tell my family that I do securities regulation, the first thing they say is, well, great, you're defending America. And for a while, I would explain to them that what I really do is financial regulation, but then I realized that they were more excited about me defending America, so I usually just say, God bless America, and we move on. In terms of what is a security is a business investment. And in terms of thinking about what federal securities law is, it's about the distribution of information. In terms of the history of the federal securities laws, you have 1911, the first blue sky law, which is a state law passed. Basically, it was about preventing fraud in the market. It was about distributing information and making sure that truthful information was being distributed. 1929, we have a stock market crash. Ultimately, the determination made by Congress was that we had to be protecting investors, and in addition to that, we wanted to protect markets. And how we were going to do that is through full and fair disclosure, meaning the caveat emptor type of standard that was used before in terms of people purchasing securities was going to be replaced by more information being out there, information being distributed freely, and that information being truthful, meaning that we weren't going to second guess what investors actually were going to be investing in, but in fact what we were going to do was to provide them with lots of information. And since the 1933 and 1934 Act, and definitely since the advent of the internet, the question that we've really struggled with is to how exactly that distribution of information should occur, what exactly it means to truthfully distribute information, and how exactly we should build systems that actually get that information to the public. So, in terms of my presentation today, I want to talk a little bit about the consequences of participating in transactions involving securities, move on to a little bit more in-depth discussion of what is a security, talk about the application of securities laws to virtual worlds, and by virtual worlds I mean online worlds, video game worlds. For those of you who are in the crowd who are familiar with Second Life, it's a world that you take on a persona and potentially you engage in business transactions in. That being said, I realize that Second Life's popularity is somewhat waning. The thing that I will say is that at some point, somebody is going to get it absolutely right when it comes to an online world. Lots of people will get involved with it, and this issue will be topical, even if you think Second Life may go away in the near future. After that, I'll talk about the problems with the current regulatory regime when it comes to the regulation of securities within virtual worlds, and maybe and after that, finish up with some recommendations for regulatory reform. Okay. In terms of the consequences of participating in transactions involving securities, for our purposes, they really can be narrowed down to two. First off, you may be required to actually register the securities, meaning making public disclosure of information regarding the securities. And secondly, you become subject to anti-fraud provisions, meaning that if the federal securities laws apply to securities transactions in virtual worlds, you can make a federal case out of it. And the thing to remember about these two different aspects of federal securities law is even if you are not required to register your securities, the anti-fraud provisions still apply. In terms of the requiring the registration of securities, we have Section 5A of the 1933 Act, one of the primary statutes regulating securities. And basically what it sets up is a default rule requiring registration. There are some exemptions for that. Probably the best one, or the one that's best known, is Section 4.2, which basically states that if you're dealing with a transaction that involves a private offering of securities, that it is not subject to the registration requirements. And you may think, oh great, well video games seem like a relatively private environment, and as a result of that, these securities laws, or at least the registration requirements, are not going to apply. That being said, we have a 1953 U.S. Supreme Court case, Ralston-Purina versus the SEC, in which the court said that in terms of thinking about a private transaction, the question you're interested in is if people have all of the facts available that they would have if they actually had a registration statement. So it's a fairly narrow exemption. That being said, there are a variety of other exemptions that are out there, usually allowing for raising low amounts of capital. Due to the late hour of the day, I think I'm not going to put you to sleep with that. The thing I will say, and as I mentioned previously, even if the registration requirements don't apply, you still have concerns about the anti-fraud provisions. Amongst those, the most prominent and probably best known, because it's gotten people like Martha Stewart in trouble, is Section 10b, and then Rule 10b-5, which is promulgated thereupon. Basically, in terms of Section 10b, what you have is a provision of the 34 Act that says it's illegal to engage in deceptive conduct and that the SEC can actually make rules. In 1942, this rule came into being with fairly unceremoniously, the notion being simply that the SEC wanted to prevent fraud. And in 1946, the thing you'll notice here is there's no private right of action, despite the fact that private people sue each other all the time. In 1946, you have the Eastern District of Pennsylvania in a case called Carden, holding that there is a private right of action. And over the years, literally hundreds of courts have acquiesced in that. The Supreme Court acquiesced in the 1970s. Doesn't terrifically like the private right of action under Section 10b and Rule 10b-5. But what it means in practical purposes, because the Supreme Court continues to hold it exists, that ultimately, if you're dealing with a securities transaction in a virtual world, not only may you be required to register, in addition to that, you may be subject to suit by the SEC, prosecution by the DOJ, and potentially even private suit. And you see lots and lots of litigation come out of Section 10b and Rule 10b-5, because when people get defrauded, they usually want their money back, even if the SEC and the government may not think that the particular case is worth pursuing. In terms of thinking about securities law and defining what a security is and putting it in terms of virtual worlds, we have two definitions. We have Section 2A1 of the 1933 Act, which looks especially fearsome on that screen. Meaning I'm guessing this is what my students' nightmares look like. And you also have Section 3A10 of the 1934 Act. The language is a little bit different, but they're interpreted the same. For our purposes and for the purposes of not completely putting you to sleep, we're really interested in one term from Section 2A1, which is investment contract. And we're interested in one term from Section 3A10, which is investment contract, and we'll get to why that's important in just a minute, and why exactly, in thinking about the application of securities to virtual worlds, it's so important as to whether or not there may be investment contracts that exist in those virtual worlds. In terms of thinking about the application of securities law to virtual worlds, there really are four different circumstances that you have to think about. The first case is real-world securities being purchased, sold, or marketed in virtual worlds. This would be if any publicly traded company opted to go into Second Life, an online game, or any sort of online environment and sell securities, the securities of its company. This particular case is the easy case, meaning that it simply would be a means, the issuer of the security would be using the online medium as a means of communication, and it's very clearly covered by the SEC. Probably not worth mentioning except for purposes of completeness. The second sort of situation would be real-world securities premised upon activity in virtual worlds. This would be if, for example, I don't know, with World of Warcraft or with Second Life, you were offering some sort of items, and in order to get startup capital for your business, you sold interests in your business in the real world. Also very clearly covered by the Securities Act, the notion being that to hold otherwise or to believe otherwise, you would have to have a similar belief that, say, for example, Amazon.com or Facebook should be exempt from securities law simply because the business exists on the internet. The third case is virtual securities premised upon activity in the real world. This would be the instance in which you simply engage completely online on selling whatever business investments, fairly clearly covered by the securities laws also. And what I mean by that is that the definition of security is long enough and broad enough that if you are simply engaging in online activity and as a result of that selling interests in your business, it's pretty clear that it's covered. The real interesting case, which is the fourth case here, is virtual securities premised upon activity in virtual worlds. This would be the case that, for example, within Second Life, where you have securities markets that have been built, people ultimately purchasing interests in businesses within Linden dollars, and ultimately there being a market created completely online. In terms of thinking through whether or not the federal securities laws would apply, what you have to look at is, ironically, at a case that arrived before us well before the internet in 1946, which is SEC v. W.J. Howie Co., which provides us a test for investment contracts. The reason why the investment contract test is so important is simply because when you think about these businesses online, even if they refer to themselves as corporations or limited liability companies or something like that, unless they've been organized by the state, what you're going to be dealing with as a default really is an investment contract. And the test to figure out whether or not you have an investment contract, it's whether the scheme involves an investment of money in a common enterprise with profits to come solely from the efforts of another. In terms of thinking through that test, courts really look at three separate items, the first of which being a question of whether or not you're dealing with an investment of money. It's pretty clear that even if you are dealing with something as simple as Linden dollars or as something as virtual as Linden dollars, if there is a link to real money, meaning a real financial interest that is at stake, that you are dealing with money for purposes of the definition of an investment contract. The second element is a common enterprise, meaning that if you're online and you're trying to solicit a bunch of investors, you have met that and you're trying to solicit them in a virtual world, you've met that particular element. And finally, the third element is whether or not it's supposed to come solely from the efforts of others. And if you're dealing with a situation where somebody in a virtual world is promising a return and promising that once you have invested the money that you won't have to deal with it in the future, and the only thing that you can expect is to get your money back plus some profit, you are dealing with an investment contract, and you are dealing with a situation in which the federal securities laws and potentially the state securities laws also apply. Notably, we only have, we do have two exceptions to that definition of an investment contract. There's an exception for unless the context otherwise requires, which is at the beginning of the definitional section. Generally, that has been applied strictly in the second exception that I list here, where there's an existence of another comprehensive regulatory scheme. It is possible that courts may reach the conclusion that what we're dealing with here with virtual worlds really just are games.